All right. Good morning, everyone. We're going to get started. I see over 130 people already logged in. I'm sure a few more are joining, but welcome back to our Environmental Essentials webinar. As many of our listeners know, this is a monthly broadcast from our Environment, Lands, and Resources team here at Bracewell, where we try to fill in the content with relevant and current items of interest. And I don't think there could be that could be any more true for our topic today, given the executive orders that have come from the Trump administration in rapid succession since the inauguration date. So my name is Jason Hutt. I chair the Environment, Lands, and Resources practice here at Bracewell. I'm joined today by Scott Segal, my partner and co-head of our policy resolution group, the lobbying and strategic communications arm at Bracewell, which serves a broad array of client interests, but with a particular focus, I think Scott would say, on energy and environmental matters. And also by Navaro, my partner in the Environment, Lands, and Resources practice, with a particular focus on the natural resources and federal lands side of the house. Anne is our go-to person on all things NEPA, which I'm sure you'll hear about, especially in the context of infrastructure development. Before joining us almost, I think about 7 years ago now, Anne had over 25 years of experience in senior legal and policy positions inside of the Corps of Engineers, as well as the Department of Interior, which are two places that she often helps our clients to navigate. So thank you both for being here. I think this is going to be a really interesting discussion. Scott, if maybe you could kick us off with sort of what is an executive order and what are its legal limitations. And I think that's probably an evolving sense of over the course of the different administrations where you've practiced here in Washington, D.C. The one thing I wanted to touch on before you get going is just if people have questions, which I'm sure they do, you can email them to me at jason.hutt@bracewell.com. And if we can get to them, I will try to get to them on the webinar today. This is typically a 30-minute session, and I'm sure that we're going to go over, just given the scope and breadth of the topic that we need to try to cover today. So if we can't get to you on the webinar today, we will follow up with you either with Scott, Ann, or myself. But Scott, set the stage. What is an executive order? What are its legal limitations, and maybe even what is a secretarial order? Because we've seen a few of those in the last week or so.
Right. Okay. Well, thanks very much, Jason. I appreciate it, and you're right. We are getting a lot of input on these executive orders and executive actions, proclamations, memoranda that come out of the executive branch. The first thing I wanted to do is just set a little level on this, which is that, an executive order or proclamation, a memorandum, can set a sense of priority or direction within the executive branch, but it can only change the content of policy in narrow circumstances where the executive has been delegated authority to do so. So, for example, emergencies, national security issues, sometimes trade policies fall into these categories of delegation to the executive branch, where the executive branch can actually say, no, this is what the going forward policy is going to be. But in many of the areas that Jason, you, me, and Ann work in, and the folks on the call, the obligations are set by statute that are passed by Congress, or the funding programs, for example, are authorized and then appropriated by the Congress as part of the power of the purse, which dates back to before the American Revolution. So these are well established as not being within the authority of the administration. That is why you'll see kind of a particular dance in some of the wording of the executive orders, which rather than calling for a particular outcome, comes right up to the edge of calling for a particular outcome and then says, I'm asking my secretary of blank or my administrator of Y to engage in the process and report back to me within 30 days about what the plan ought to look like. Why? Because there's supposed to be a degree of deliberation within administrative process. And if you're going to have to change an extant regulation, then you're going to have to do so through the administrative process, which requires notice and comment and requires almost at times like a quasi-judicial undertaking. So you better have papered, you better not have presupposed the outcome. Let me give you an example of where in an executive order, where we're knocking on the edge of how far they can go, where the outcome seems to be presupposed. One of those was the funding freeze that you find in the Unleashing American Energy executive order, which applied for a period certain for money being spent under IIJA, which is the infrastructure bill, or the Inflation Reduction Act, the large climate package that passed under budget reconciliation back in 2022. Well, I mean, y'all remember, I'm just a bill here on Capitol Hill, right? Those were both pieces of legislation that were passed by two houses of Congress and signed by the president that cannot be overturned by an executive order. The reason I said it comes up to the edge of presupposing an outcome is because if you read that section 8 of the unleashing, what I call the unleashing executive order, it says we're going to review this spending to see if it's consistent with our statement of how we think the policy ought to be set that we reflect in section 2 of this executive order. No. The Congress sets the policy. If they want to replace that policy with newly articulated policy, who has to do it? The United States Congress, which is why we have seen so much litigation regarding these executive orders. But just to give you an idea, I know why you're on this call. It's the same reason we're not sleeping very well, which is there is so much executive action. It's almost difficult to keep it all in mind. I'm going to use a primitive form of audiovisual communication right now by holding up a chart. All right, what this chart is the total number of executive orders by the 100th day of the last several administrations. Okay, so what we see here is, Ronald Reagan, who was criticized for having too many executive orders, 18 at the 100th day. And then, 11, George H.W. Bush. Bill Clinton, 13, had some very important executive orders dealing with regulatory reform that we still work with today.
And
George W. Bush, I guess it's genetic, also had exactly 11 executive orders, just like his dad. Obama, a very active administration, 19 executive orders. Trump 1, also active. Remember, big day one, a stack this tall. That was 33. Here is this administration, the second Trump administration. 56 executive actions. In fact, it's 57 if you count aluminum and steel that just happened the other day. So 57 executive actions. And ladies and gentlemen, we're not at the 100th day. We're at the 23rd day, right? So it's already this much more than all the others at 100 days. So one of the things I would say in terms of level setting is we're not going to cover all these executive actions. We're going to select some particular ones. Now, as I prefaced a moment ago, ones that we probably get, at least in our group, Jason, that we're getting the most questions about is, what does this do to loan guarantees? What does this do to tax incentives? What does this do to grant making authority of the federal government that arises under IRA or under the bipartisan infrastructure bill? And the first thing I want to say is tax credits are set by statute. So the executive orders do not even attempt to reverse the tax credits, except in two cases. One is the president has called upon the Secretary of Treasury to review essentially the effectiveness and recommendations regarding some clean energy, not all, but some clean energy tax incentives. And secondly, if a tax incentive is positioned such that it is direct pay to a transaction or to an individual or a corporation that would not otherwise pay taxes, that is more like a disbursement, which is the term that is used in the unleashing executive order. What is really at risk here are loan guarantees, because loan guarantees have to be backed up by an appropriation, and grant-making authority, which is a direct withdrawal from the federal fisc. So those are the most in danger, and that is where we have seen the most litigation. More than 10 of President Trump's executive orders have been challenged in federal court at this point, and roughly half of those are already facing some form of preliminary court order that halts them in part or in whole for a period of time, pending a larger discussion and briefing of the merits of the case. Trump's freeze on federal spending, which we've been talking about, Section 8 of the Unleashing Executive Order, January 27th, OMB followed that up with a now infamous memorandum, which they then had to withdraw when it was subject to a lot of criticism. And that criticism didn't just come from two federal judges. That criticism also came from Republicans on Capitol Hill who quietly went to the White House and said, you know, we've got projects we're building in our jurisdictions that now are just wondering if it's going to proceed. And remember, I don't tell anybody on this call, but you have your own milestones when you're advancing a project. And when you're told you have a loan guarantee or you're told you have a grant from the federal government, that's pretty good. But that has I think the phrase is the full faith and credit of the federal government behind you. And so you may proceed to the next milestone. When you are told all of a sudden that may be in doubt, you begin to break milestones, in which case you may fall behind, and it may even if it's just a temporary delay can undermine deals. And of course, we all know that. The most recent thing I wanted to point out, I'm sure everybody knows this, but the most recent action in court, and I'm loving holding up props, is this court case, this order that was entered just the other day by Judge McConnell for the Federal District Court of Rhode Island. The plaintiffs petitioners were states who remember, states often receive money that they in turn spend on projects within their states, saying that they were aggrieved parties. And essentially, the federal courts were being, at least in their opinion, were being ignored, because what the government did was withdraw that OMB memorandum, but continue to keep the funding freeze in place. And it is true, whether it's because of youngsters from Doge who have their finger on the check writing technology, or whether it be because of a high level decision that's being made, money was not flowing, and that seemed to be inconsistent with Judge McConnell and Judge Ali Khan's decisions in two separate jurisdictions. So this Judge McConnell wrote this executive order, and this temporary restraining order, which begins without even any language. It begins simply with a long quote from the Supreme Court. And I thought I would read you just a little of it before I turn it over to Ann to talk about implications on permitting reform, because otherwise I'm just going to keep talking forever. What the judge quotes is, and it has some bolding in it too, it is a basic proposition that all orders and judgments of courts must be complied with promptly. Persons who make private determinations of the law, right? Now that includes Elon Musk on X or wherever it may be, private determinations of the law, and refuse to obey an order generally risk criminal contempt, even if the order is ultimately ruled incorrect. So when J.D. Vance says, for example, these are all activist judges, shouldn't trust him, even if he's right and they ultimately are ruled is incorrect, you still have to comply with the order when it's entered. Now, it does lead to a very strange thought, which is 40 staffers is the total number of staffers at Doge, of them being confronted by U.S. Marshals. I mean, I don't know. And that is the point I want to make before I turn it over to Ann. We are at the edge, ladies and gentlemen. We really don't know exactly how this story plays out. Is it like President Andrew Jackson, who in defending the removal cases said John Marshall has made his decision, now let him enforce it? In other words, are they going to make the courts try and enforce their own decisions, or are they going to do what all the other folks on that bar chart I showed you have done when their actions are challenged, which is to say, well, if there's a legitimate court order, we're going to stand down. Has, with 57 executive actions now, has the zone been effectively flooded, so that even if the judicial branch took it seriously and began issuing order after order, could they just simply not go fast enough? I mean, if you denude an executive agency of both staff or funding, by the time you put the pieces back together, it may be too late. If you deny someone federal funding and they miss milestones, as I discussed moments ago, by the time it is resurrected, it may be too late. So can they continue to push this? Is this Andrew Jackson in the 1830s? So, I mean, these are very, very fundamental questions that we don't really have answers for. Maybe we'll have more answers when we talk about shifting sands with respect to permitting and leasing. And the only way I'm going to know that is to turn it to Ann Navaro. So Ann, why don't you go next?
Thanks, Scott. Sure, happy to. And actually, I heard a long story on the radio this morning about what could happen if there are legitimate court orders and the executive branch fails to comply with them. So worth listening to. So I wanted to talk a little bit about the implications of the executive order kind of in the practical space of how we're going to build infrastructure and energy projects, because there are a number of components of the executive orders that pertain to kind of the in the weeds practical implications of permitting. The executive orders, of course, have implications for the National Environmental Policy Act, or NEPA. But there's also a lot of other swirling things going on around NEPA, so I might save that for last. And they also provide direction on the Endangered Species Act, Corps of Engineers permitting, and environmental justice, which are all kind of key things for permitting in, for various federal agencies, including the Corps of Engineers, all the bureaus of the Department of the Interior, FERC, and other federal agencies. So I want to talk a little bit about the Endangered Species Act, because I find this point, and maybe because I like to get down in the weeds, a little bit interesting. So as you all may know, if the federal government is going to give you a permit or a certificate order or a right-of-way, a lease, any sort of authorization or approval, or a federal grant, they're supposed to comply with the Endangered Species Act, particularly Section 7, which requires the permitting agency to consult with the Fish and Wildlife Service or the National Marine Fisheries Service to make sure that their actions don't jeopardize the existence of a species. And anybody who has worked through that process knows that it can be time-consuming, it can be frustrating, and it can result in requirements for the project that may be onerous for the project from a resource or implementation perspective. And so that is obviously on the radar of this administration, because one of the executive orders, and now I'm forgetting, I think it's the Energy Emergency Executive Order, addresses ESA consultation and says, hey, agencies are directed essentially to use the emergency consultation procedures under the ESA to facilitate energy projects in particular. So you might wonder, you might think, great, we're going to get through this process really fast, and that's going to be really helpful. So it will be interesting to see how the Fish and Wildlife Service and the National Marine Fisheries Service actually roll this out, because the ESA itself has no statutory emergency provisions or exceptions. In the regulations that those agencies implement, there is a provision that applies to, and I quote, situations involving acts of God, disasters, casualties, national defense, or security emergencies, etc. So we may be in the security emergency or etc. category in terms of this provision, and it allows the Fish and Wildlife Service, or NIMF, to conduct consultation through alternative kind of informal procedures in order to get an emergency addressed. But it also says that consultation shall be initiated as soon as practicable after the emergency is under control. So 2 questions. Does this situation qualify as an emergency that's covered by the regulations? And then if it does, and you move forward a private project after that informal process, what does it mean that it still has to go through a formal consultation after the emergency is under control? Are you still going to be subject to mitigation, enhancements, other sorts of compliance? And what are the implications for you? Nothing about this changes the flat out prohibition in the Endangered Species Act that criminalizes take of endangered species unless you have the protections of a permit or a completed Section 7 consultation. So the other thing to consider is, does it expose you to potential project opponents or litigants in some other way? And if this process is used, might that pose some sort of future litigation risk for your project? So it'll be interesting to see how all that plays out and what sort of guidance comes out from the Fish and Wildlife Service and NIMFS on how to use that. And I wanted to yes, Scott.
I was just going to say, since you raised, I had intended to go through at least some of the executive orders. Since you raised energy emergency, I just wanted to, first of all, remind everybody, of course, there's an executive order that declares an energy emergency. We're not 100% sure what that means. The basis of the emergency seems to be predicated on demand, which is not the basis of past. Like, we don't have the situation we had after the oil embargo, for example. When Carter declared an energy emergency in 77, we don't have that situation. In fact, the United States is largely energy independent as we speak, so we don't really have that. But we do have notions that we have for the first time in 20 years, an increase in flatlined energy demand on the electricity side of the ledger for reshoring of manufacturing and for artificial intelligence and for data centers and the like. So that's the nature of the emergency. If that doesn't quite sound like an emergency to you, that we may end up getting case law which defines the four corners for the first time of the International Emergency Act, Energy Emergency Act, IEPA. We'll have to see. I mean, I'm sure people will. Yeah.
So Scott, so there's always been these emergency escape hatches in the laws and in the parameters of the Constitution. I remember when President Biden first came into office, he was urged to declare a climate emergency, right? And he declined to do so. I've spent the last several years litigating about whether there can be an emergency associated with long-term exposure to a pollutant. What is the difference this time? Like, is it IEPA that they can hang their hat on that hook as the basis of saying there's an energy emergency? And why is that different from the climate emergency, which is like an emergency in the opposite direction?
Right.
That President Biden declined to pursue, as a basis for his policy. Although ultimately he got the IRA passed, and I think that was his achievement with respect to his climate change position.
Well, okay, a couple things to think about here. First of all, the energy emergency in the executive order references a reservoir of authority under something called the Defense Production Act, or DPA, which is existing law and has been existing law for a long time. Now, usually DPA is predicated on a national security threat, where let me give you the classic example. It's timely right now, right, Jason? Because we just had a steel and aluminum executive order a moment ago, but not enough steel to build the ships or build the armaments. So the federal government basically is able to increase the production level and or open new plants using Defense Production Act. That's the historical way to do it. The interesting part is where Ann comes in on this, because DPA has not typically been used to waive regular, like permitting requirements or things like that. Expedite, yes. Waive entirely, no. So it's an interesting question. The reason I call it one of those narrow exceptions for executive authority is because few are the courts that want to substitute their judgment about what is or is not an emergency for what the executive. The argument is the executive sees more than they see, and it's in the institutional competence of the executive branch to determine if we're in an emergency. But if you push it far enough, you will find the limits. And so that's the question of, is it being pushed far enough here? By the way, why Joe Biden didn't declare a climate emergency is because the one law you cannot lobby is the law of unintended consequences. And I believe that the Biden administration, despite all of the loud voices on climate change and environmental justice across the government and all of those high principles, was of the judgment they just didn't know what would actually happen in terms of litigation, citizen suits and the like. What would happen if they actually declared a climate emergency? And they decided they didn't need it. They had all kinds of other regulatory tools at their disposal, and eventually they passed IRA. So that's why they didn't do it. I think the law of unintended consequences is a little less troubling to the current administration than it was to the last administration. By the way, I'm not saying that's a bad thing. I'm just saying it is what it is. And so as a result, they are willing to take the risk. I think that the last administration wasn't willing to take. One other source of authority that is not mentioned by name in the energy emergency declaration, but is worth people thinking about if you're on the electric side of the spectrum, that is Section 202 of the Federal Power Act, which is what we in the olden days used to call a must-run order. For those of you in Texas who might have tuned in, let's say you had a winter storm. Let's say the winter storm caused a load shedding event. The 202C of the Federal Power Act allows you to say, well, this is an emergency, so facilities that are only supposed to run for a limited period of time, or we're supposed to be shut down, we're going to bring them back online in order to make sure that they run. So let's just, but historically, 202C has been governed by limited duration events, usually related to natural emergencies. And here, the suggestion is, I mean, there's nothing about AI and data centers which constitutes a natural emergency, right? So here, the suggestion is using these authorities for broader purposes, and that's the kind of thing that a court could pare back on if an attempt were made.
So speaking of emergency authorities, the Energy Emergency Executive Order also directs the U.S. Army Corps of Engineers to consider use of its emergency permitting procedures. Note that neither the Clean Water Act nor the Rivers and Harbors Act, the two statutes under which the Corps does the most permitting, have any sort of cross-the-board emergency permitting authorities. Again, kind of like with ESA, there is a provision in the Corps' regulations, kind of what I would call a, practical acknowledgement of the fact that emergencies can happen that must be dealt with immediately. And there's got to be some sort of regulatory recognition of that. And so the Corps of Engineers has a regulation that says the division engineers, so that's the in-the-middle people between the Corps of Engineers districts that do the permitting and Corps headquarters, are authorized to approve special processing procedures in emergency situations. And then it goes on to define an emergency situation, actually a little more specifically than the ESA regulations do. They call it an unacceptable hazard to life, a significant loss of property, or an immediate, unforeseen, and significant economic hardship if corrective action requiring a permit is not undertaken within a time period less than the normal time needed to process the application.
Does a ship taking out a bridge in Baltimore count under those
provisions?
I
would say that counts. But, I think originally those were the type of incidents, or, a dredge hits an oil and gas pipeline, in a channel, and immediate action has to be taken to remedy the situation. I think those were the type of instances that were originally contemplated under this regulation. It's also true that some Corps of Engineers districts have regional general permits for emergencies. But again, the few that exist are tailored towards those type of immediate situations. And then the reg goes on to say, like the ESA reg, even in an emergency situation, reasonable efforts will be made to receive comments from interested federal, state, and local agencies and the affected public. And it also contemplates the potential for an after-the-fact permit, or the issuance of a very fast individual permit some districts will do. So again, it doesn't really remove applicants or potential applicants from all requirements, except probably in the most extreme of situations. The statute itself does use the phrase emergency. The Clean Water Act does, but it states that activities don't require 404 permits under the Clean Water Act if they're emergency reconstruction of recently damaged things. So again, a very narrow exemption. The other thing the Corps has that it may look to using more aggressively is some statutory authority to accept funding in some circumstances to expedite Clean Water Act and Rivers and Harbors Act permitting. By statute, that is pretty narrowly available to things like utility companies. And in my experience, it also does little to actually expedite the permitting because of the general workload at the Corps. So, all that to say, remains to be seen how the Corps of Engineers is going to interpret that directive in the executive order and how it will ultimately affect permitting, if it does at all. The executive order also directs, aggressive use of the Corps' nationwide permitting authority. I'm sure a lot of people listening today use nationwide permits to build projects. They typically are more efficient and faster than having to get an individual permit. They're already pretty comprehensive, even though some of them have restrictions. So there's a new round coming up. The Corps should be proposing a new round of nationwide permits for public comment soon. And so I think the question will be, are they going to make any more available? Are they going to take off some of the restrictions? How will they change? They've still got to meet the statutory threshold, which is the activities subject to the permit will cause only minimal adverse environmental effects when performed separately or cumulatively. So still some restrictions that the Corps has to operate in. I'm going to pause there. We can talk about NEPA, but I see we're at, or EJ, but I see we're at 10:03.
Well, let's talk about EJ and DEI, because I think it overlaps with both of you, right? And you're trying to advise clients about how to consider those things now in the context of NEPA and other analyses. Scott, you're looking at it from a funding standpoint. How are you thinking about the executive? How are each of you thinking about the executive order on environmental justice and diversity, equity, inclusion?
Well, first of all, with respect to the organizational underpinnings of environmental justice across the government, which was sort of the watchword of the Biden administration, the administration, just as those offices were set up pursuant with a large degree of executive discretion, the president has very little problem, I think, in knocking those offices over in various government agencies. And so the first question is, who's minding the store on environmental justice, if that's still an operative concern? The funding issue that you raised probably goes more to the Justice 40 initiative, which was a mechanism essentially for evaluating community benefit for funding that flowed from IRA. And basically what it said was that 40% of the benefit had to flow to I'll just call frontline communities. And let me just say that this was never a particularly well-defined concept. And maybe I'm too quick to call everything illegal, but I never thought if it were actually used in a way that had almost a statutory impact, I think it was on weak ground as it was, although it does have some linkage to the underlying statute. So that pretty much is not available anymore. And of course, there's a broader public debate going on about DEI issues and the extent to which the DEI issues should be encouraged by the federal government. And I think that reflects, particularly if you're going to use environmental justice as a basis for calling balls and strikes on environmental enforcement initiatives, I think that there's no one that's going to be doing that anymore. Jason, as you well know, because you've been on the front lines on issues like that. But Ann, you may want to talk about it from a permitting context.
Yeah, so that's the way I come at the environmental justice issue, is really in the context of what our agencies obligated to analyze as part of their review of a project under the National Environmental Policy Act, which folks on the phone, I'm sure know, requires the government to do a look at the potential environmental impacts of its action and alternatives to those actions. So, since the beginning of NEPA time, almost, agencies have been obligated to review reasonably foreseeable environmental impacts that were defined in the regulations to include economic, social, and health impacts. So there's kind of that context, and we'll talk about what's going on with the NEPA regs. But then there was the environmental justice executive order in the 90s, which compelled federal agencies to specifically look at it through an environmental justice lens and imposed certain requirements. That executive order has now been withdrawn, and so obviously is no longer relevant to federal agencies. As for the NEPA regulations, I'm sure, as a lot of people know, they are dead or nearly dead. It tends to be a little bit confusing. The DC Circuit held that CEQ did not have authority to issue them, but in the rehearing denial, a statement from some of the judges indicated they thought that was dicta, but a federal court in North Dakota made the same ruling and vacated the 2024 NEPA regulations, strangely, saying that in their place, the last version would come into effect, which was the Biden phase 1 NEPA rule, which was mostly the Trump administration's NEPA regulations with a couple of minor revisions. So it's a confusing state of play for NEPA. I think the NEPA regulations, if they're not already dead, will be shortly when the Trump administration takes action to formally revoke them. And so then the question remains, do agencies still need to look at social, economic, health impacts, and does it need to be wrapped in an environmental justice, wrapper? Already we're hearing that some agencies are telling applicants that they don't want to hear about environmental justice. Obviously, we've yet to see how that's really going to play out. And I expect, despite the revocation of the NEPA regs ultimately and the revocation of the executive order, there will be continued NEPA litigation testing whether NEPA requires this type of analysis.
I think too that you're going to start hearing, remember the social license to operate concept that we heard a lot about in prior administrations, but companies have made commitments with respect to EJ and DEI that are outside the context of generating a legally defensible permitting decision from the federal agency. And so companies are going to need to navigate the idea of, well, maybe I need to do one set of things to check all the boxes to get a legally defensible permit, but I also have to do certain other things to live up to the commitments that I made to shareholders and other stakeholders in statements that the company has made and sustainability reports and other things like that. I mean, it has embedded itself somewhat in the DNA of this process. Scott, as you said, the part of it that was embedded inside the infrastructure of the executive branch, they've ripped that out because they can. But I think it still has some staying power. So that's going to be a tricky road to navigate going forward.
Well, let me give you an example of that, of the difference between being able to take out the architecture versus being able to take out the issue. So take, for example, something that's clearly within the self-executing power of the executive branch, stepping out of the Paris Accord, right?
Mm-hmm.
Or on climate. That's something. Foreign policy is one of those areas that's given over to the president. U.S. v. Curtis Wright, the executive branch is the sole organ of foreign policy, so he's able to do that, and he's done it. He's provided the notice, which has to mature over a year, by the way, but he's provided the notice to the UN that we're stepping out. We're ending funding for some of the other UNFCCC programs, although we're not stepping out of the Framework Convention because that would likely require a Senate action because it was Senate ratified, so it would require Senate action. And he doesn't really like talking to Congress either. So that the funding is what he's focusing on there. Indeed, ending the funding for UNFCCC might also be illegal, but there's so many things. There are only so many things you can sue over in a day. Okay, so that's an example. But what about voluntary carbon markets? We've got a piece out right now from the firm. The lead authors of it really are in our London office. But what about the impact of stepping outside, of using voluntary carbon markets as kind of a barometer for how outside of the mainstream you can get simply by stepping outside of Paris. And the answer is probably not that much so, because first, of the social license to operate, which you were talking about, but also we have some history on this. Because remember, this is now the second time we've stepped outside of Paris. The first time we did it was in the first Trump administration, and markets for voluntary carbon credits did not decline precipitously as a result of the U.S. stepping out of Paris the last time. So these are international markets, and the quintessential issue here is, can you put the genie back in the bottle? And on climate change, on a lot of DEI initiatives, it's very difficult to visualize putting the genie completely back in the bottle. Will these issues, have less enforceability? Of course. Will these issues perhaps have less sting than they once had? Will people be more careful about the rhetoric they use to describe them? Of course. But will they completely cease to exist as a result of executive orders? No, of course not. That's not the way around it. Plus, we've also said for many of these issues, they're not self-executing anyway. And that I did want to quickly answer a question you asked me at the beginning. Secretarial orders, I'm just going to say this. Where the rubber hits the road is at the agency heads. That's why Ann has spoken a lot about the Corps of Engineers, for example, what they do, how they interpret the executive orders is as important, if not more important, than what's actually in the four corners of the EO. So must reading for everybody on this call. You must read Chris Wright, the Secretary of Energy's discussion of how he visualizes the going forward mandate of the Energy Department. It's good. It's good stuff. He strikes me as somebody who doesn't tend to throw a lot of curveballs, but he basically framed his going forward message around the unleashing energy dominance rhetoric that's found in the unleashing executive order. He set out 9 principles that talked about increasing innovation, good thing, because that's where the national labs are located, LNG exports, nuclear power. He opposes net zero policies, but he targeted efficiency rules. For those of you who are in the appliance business, you know that regulatory authority is one of the few regulatory authorities that DOE has on its own. He emphasized a focus on nuclear fusion, computing, AI, fossil fuels, and everyone's favorite new renewable power, geothermal, because it has really good politics if you look at East-West politics in the United States. Lee Zeldin had 2 pieces that ought to be on your mandatory reading list. One is a single page, half a page memorandum that he sent to employees, and it was followed up by a speech to employees at EPA. And the part I wanted to parse out there is he emphasized his own bipartisan approach. Remember, he was a congressman from Suffolk County, from Long Island. And if you're a Republican from Long Island, you have to be bipartisan. And so he was, and he voted in favor of PFAS regulation, for example, when he was in the House of Representatives. And he promised, and this is an interesting point, he promised to, quote, fight for the agency's budget on Capitol Hill, which is, of course, music to the ears of people that were listening. He is a politician. That's part of it. But those are also a bold thing to say in this day and age. He also set out 5 pillars, some of which will make total sense to you, like pillar number 1, clean air, land, and water. That is the way Donald Trump always refers to the necessity for environmental protection. He said he would focus on environmental protection while being fiscally responsible. But the other pillars are going to sound maybe a tad tinny because they're not really EPA jurisdiction. American energy dominance, permitting reform, I think, is EPA jurisdictional. Artificial intelligence doesn't really strike you, but what he basically said is all regulatory agencies need to position the United States to lead on AI development, and including providing clean power facilities to advance AI, which is an interesting point to make. And his pillar 5 was restore the automobile industry. And you might not think that's jurisdictional to EPA, but it really kind of is. And he's referring to a suite of 3 regulatory actions, which he is in the process of revisiting, if not overturning completely, via the Congressional Review Act. And those are tailpipe standards, the EPA part of the CAFE program, and rejection of the California waiver, which allows California extraordinary additional authority in the area of mobile sources. Other areas too, but mostly utilized in mobile sources. The last thing is I really want to show you what a secretarial order looks like in the Department of Transportation. The first thing that Sean Duffy signed after being confirmed, a secretarial order which reopened the CAFE program and begins the process of resetting the numbers under CAFE, which you're able to do under the statute. So they're on pretty strong legal ground. And he wasn't just walking around with that, on his things to do list. That was obviously pre-drafted and ready to roll. And so if you combine that with Lee Zeldin's fifth pillar of dealing with the auto industry, you see a real sense of administration priority, and that's where the rubber hits the road. An EO that says we're going to revisit these 3 rules, that was in the Unleashing Energy Independence EO, but it doesn't become real until guys like Zeldin and guys like Sean Duffy, the Transportation Secretary, actually put pen to paper, and they've begun that process already within the first 23 days of the administration.
And, following up on that point, that it doesn't, and I realize we're coming to the end of the hour, that it doesn't become real until it's implemented at the agencies. There are a couple other nuggets in the Unleashing executive order in the context of environmental reviews that should be done by the agencies in permitting. For example, buried in the executive order, the president directs that agencies shall adhere only to the relevant legislated requirements for environmental considerations, and any considerations beyond these requirements are eliminated. Now, I think that's getting at what has become a frustration over the years, that some federal agencies seem to be looking at issues that are well outside their ability to control, well outside their regulatory authority. For example, the current Supreme Court NEPA case, hopefully we'll see a decision, by June, the 7-county case. The issue is whether the Surface Transportation Board, which was permitting the 80-mile long railway, had to look at air emissions in Utah, by the way, air emissions on the Gulf Coast as a result of burning crude oil that was going to be transported in that 80-mile section of railway. So I think that's an example. But I think, here's the problem. What does relevant legislated requirements for environmental considerations mean? Because when NEPA was amended a year and a half ago, Congress codified the requirement that agencies consider reasonably foreseeable environmental impacts. That phrase had been in the CEQ regulations, which are now going away, since the beginning of time. That phrase has also been the subject of umpteen million judicial opinions, right? That's a relevant legislated requirement for environmental considerations. But it also is a very broad phrase that the courts have interpreted as sweeping in all sorts of things. So, again, another element of the executive order that will have to be, the agencies are going to have to figure out what that means, if anything, for them. And then, perhaps most importantly, the courts are going to have the final say on that. And so, the question for applicants to the federal government is, do you want to be the tip of the spear on some of these issues? Or are you and the agency going to want to play it safe in terms of what you're considering?
There's definitely a tension here in the sense that the order says don't mission creep if you're going to go in the direction of things I don't like. But if you want to mission creep in the direction of AI and data centers, that could be a secretarial order inside of the Environmental Protection Agency. So
but Jason, there is a lot of tension even among the executive orders themselves. Like, for example, let's assume there was a single author for all the executive orders. All right. I mean, technically there is. He has a Sharpie, right? But let's assume there were a single author. Does that author like the National Environmental Policy Act or dislike the National Environmental Policy Act? Let me explain. If one were to read the executive order on offshore wind, one would come to the conclusion that a muscular NEPA that asks all the right questions, or a muscular and ESA that asks all the right questions at all the right time, it doesn't give any ground or water, right? That's the regulatory program we're looking at. But if one looks at the restore offshore federal development of oil and gas on federal lands and restore
Alaska,
leasing in Alaska and OCS,
NEPA is an impediment.
NEPA is an impediment. All of a sudden, it needs to be put in a cage, right? So there is. I think Charles Atlas referred to it as dynamic tension between these two principles, and this is true in many other parts of the executive orders too, where there's kind of tension between the
Of
the
course,
two
every
elements.
administration has its competing policy priorities.
Yeah.
So
Okay,
that
so-
writ large, maybe that's not unusual. But
No, and maybe it's good.
So we only have a few minutes left in our oversized webinar, and I
Yeah.
don't think that you can do a webinar on the executive orders. I heard there's a thing or two going on about trade, Scott.
Yeah.
And it relates especially to our physical neighbors to the north and the south. Hum a bar or two on
Sure.
the tariffs and how they apply or do not apply to energy, because I think
Yeah.
that's something that's obviously a focus of our listeners.
Right. Well, okay. First of all, just review the bidding. As you know, imposition of a 25% tariff on Mexico and Canada, only a 10% tariff on so-called energy and energy products from Canada. Apparently, a full 25% for energy and energy products from Mexico. I had somebody ask me, does that mean it doesn't apply to energy at all for Mexico? And I was like, no, it means you fall back into the soup for the full 25%. The whole thing, as you know, has been delayed. The president has signaled 1 month, and the president signaled that that's probably not long enough. Now, what's interesting is because there's this differential treatment for Canadian energy, it forced the executive order to define what energy and energy products would look like. And they took the definition from the Energy Declaration of an Energy Emergency, the other executive order. I think it's 14-156 or whatever. That's one of the ones that has a number already. Okay, that maybe end up being the most important part about the energy emergency executive order is that it provides the definition for the trade exception for Canada. And it's a very broad definition. A lot of people only look at part A of that definition, which is all the traditional, like oil and gas, stuff like that. But if you look further in the energy emergency thing, it also says with respect to generation and transmission of electricity. So it's a rather broad definition of, and there is some history in the distant past of applying countervailing duties to electricity flows across the border. So we're going to see, we're going to see some implementation of this. The president's already said that the 10,000 troops on both sides of the border being sent by Canada and Mexico is not sufficient. Truth is, actually, Canada and Mexico had already agreed to that in the last administration, but just hadn't made a big deal out of it for domestic political reasons. So once that gets out, that's really going to take the bloom off the lily of that being sufficient. So we're going to see that. Obviously, it has a disproportionate impact, Jason, on Midwestern refineries, for example, that are heavily dependent, otherwise isolated, heavily dependent on hydrocarbons from Canada. If you view unleashing America's energy dominance as being kind of a North American issue, there's almost a single market, or at least a highly integrated market between Canada and the United States. Less so with Mexico, but more a highly integrated market there. So it's going to be difficult to see how it's implemented. The other thing I want to say for everybody, though, is what happened last night in trade, which is the president hinted at it during the Super Bowl and then made it real yesterday for the aluminum and steel tariffs. We've been this road before. In the sense that we've had aluminum and we've had steel tariffs. He's now adding aluminum to that. He signed separate executive orders on the two. Most oil and gas companies, for example, are quite affected by steel and aluminum, but they've been a little bit subdued in their response to the administration because there are many positive things the administration is also doing for oil and gas. I did want to point out that for those of you who are interested in carbon capture and sequestration, you may recall a news story last year about the special anti-corrosive steel that is necessary to do carbon capture. We don't really make that in the United States. So over and above steel grade, oil country tubular goods, which is the trade name for pipelines. We also have specialized issues with respect to carbon pipelines that that are very difficult to do with a very high tariff on steel or aluminum. And we're not likely to make that steel anytime soon in the U.S. So anyway, that's a quick trip down trade lane, which could be an entire separate. It could be a entire separate discussion, with people other than me.
I think it's more like Lombard Street than a lane, but
that's right.
Okay, well, we're at an hour. This is normally a half an hour episode. Thank you everyone for joining us. As I'm sure you gathered from the discussion, it is a fascinating time to be at the intersection of environmental and energy policy and legal matters. Just going to our lunchroom every day is something that I enjoy hearing what everyone is thinking about and working on. So please feel free to reach out to any of the three of us. Each of our emails is our first name dot our last name and then @bracewell.com. If you don't know who to send it to, please feel free to send it to me and I will get it. I'll get your questions to the right person. Thank you, Ann, and thank you, Scott, for making this an entertaining and informative hour discussion on what's happening in Washington. I'm sure that we will likely have a follow-up as things continue to evolve here. And thank you, everyone, for joining us for the hour. We appreciate it.